Good afternoon or good morning or good evening, everyone, wherever you may be joining today's webinar. It's my great pleasure to welcome you to the second webinar in the International Human Rights Litigation Challenges and Frontiers webinar series that has been co-organized by Matrix Chambers and the Bonavero Institute of Human Rights. My name is Başak Çalı. I'm Professor of International Law at the University of Oxford and Head of Research at the Bonavero Institute. And I'm one of the co-organizers of this webinar series together with Professor Philip Leach. Today's discussion focuses on litigating authoritarian practices. Admittedly, this is a topic for which we could perhaps organize a day or maybe a week-long conference. And I hope that one day, some of you who are in this webinar will definitely do that and also invite us to that conference. But one of the reasons why I was saying it is because authoritarian practices are currently present in many countries and in all regions of the world. And in fact, quite a lot of the political science research tells us that a larger part of the population in the world currently live under authoritarian regimes than under democracies. So this is a very widespread practice that we are experiencing wherever we may be. But secondly, the scale, the complexity, and the interrelatedness of authoritarian practices are really overwhelming from a litigation perspective, because litigation works as one case at a time, and these practices have such a huge scale and they affect such larger groups of individuals, but also institutions, that make it very difficult, perhaps, to address through human rights litigation. Putting these points aside, I have an absolutely excellent panel today to discuss these issues with me, and we will also be able to reflect on litigating authoritarian practices in three regions, in the three human rights systems, in Africa, in Americas, and in Europe. So let me very briefly introduce our speakers to you in the order that they will speak. Our first speaker is Philip Leach. Philip is a member of Matrix Chambers and Professor of Human Rights Law at Middlesex University. He's a serial litigator at the European Court of Human Rights, including many cases concerning authoritarian practices. And our second speaker will be Adem Kassiye Abebe. And Adem is Vice President of the African Network of Constitutional Lawyers and Senior Advisor at the Constitutional Building Team of the International IDEA. He's also a member of the Advisory Council of the Bonavero Institute of Human Rights and extraordinary lecturer at the Center for Human Rights at the University of Pretoria. And our third speaker today will be Viviane Krstiewicz. Viviane is the Director of Center for Justice and International Law, also known as CEHIL. And in this capacity, she litigated extensively cases that led to transformative changes across Americas, and her work has contributed to social change through litigation, community support, advocacy in gender equality, accountability, climate justice, and human rights defenders cases and struggles. She also played a key role in the development of the Esperanza Protocol. This is regarded as a blueprint for protecting human rights defenders. Viviane is currently a member of the expert panel of the fact-finding mission on the Islamic Republic of Iran, established by the United Nations Human Rights Council, and also a co-founder of the GICU campaign on gender parity in global decision-making roles. Before we start off our speakers and their interventions, let me just also let you know that you can pose your questions by using the chat function throughout the webinar. You can type your questions as and when you would like to. And after we hear our presenters, our speakers, we will come back to the questions that are posed by you in the panel, and we will finish at 2 o'clock sharp. So we will be only able to accept questions until that time. So thank you very much for joining us today, and over to you, Phil.
Thank you very much, Başak. Hello, everyone. It's a great pleasure to be here on this panel, and I've been asked to start off just to say a few words about the European system before we hear in a little bit more detail, a bit more depth about both the African system and the inter-American system, but I hope it'll be a very good opportunity to compare current issues and current strategies faced with authoritarian practices around the globe. In terms of Europe, I wanted to say something about the system and the practice of the European Court, but also about the substantive law in 4 or 5 minutes that I have. And I'm going to start with the interim measures process, also its provisional measures, precautionary measures in other systems. And what we've seen, what I think has been very, very interesting in recent years, is the court moving beyond the usual Article 2, Article 3, right to life, integrating treatment paradigm in immigration deportation context to use the interim measures procedure, the legally binding directions to protect civil society in all manner of, in a number of areas, particularly to protect the media in cases from Georgia, Ukraine, and Russia, to try to ensure the continuance of the existence of human rights organizations in Russia. That's the Memorial case, and most recently to in an attempt to bolster and support the independence of judges. Particularly, there's been a whole series of interim measures cases in relation to Poland. So that's one area it'd be interesting to discuss with Jana and Adem. Going on to the substantive developments in Europe, we've seen over a longer period, about 20 years, actually remarkable development of provision was previously totally dormant. This is Article 18 of the European Convention on Human Rights, the provision that prevents states from applying restrictions to our human rights for ulterior purposes. And this provision has been used to counter the repression of dissenting voices, particularly in Azerbaijan, in Russia, in Turkey as well, and in other states. And it's been invoked by human rights activists, by journalists, by politicians, and more recently judges as well. And it's a significant development because the court uses Article 18 to call out bad faith, to call out deliberate and targeted repression by European governments against dissenting voices, and that's a significant development. It's a kind of very tricky issue in any international court, and it's been used in the European context in primarily in cases of where people are prosecuted, so that it's pretrial detention, but also in relation to other measures of repression, such as raiding offices, such as freezing bank accounts, such as preventing people from leaving the country, so freedom of movement. And so on. And the most recent development in relation to Article 18 is its development, its expansion to apply also to the right to fair trial. So just in the last year, and before that time, we had a strange situation where Article 18 could be applied in relation to pretrial detention, but not in relation to the actual trial process, which I thought certainly was illogical and absurd and unjustifiable, and that's changed now. So I think we'll see a flourishing of cases in relation to Article 18 and the right to a fair trial. Those cases, the Article 18 cases, have had interesting and important impacts too. The court has shown itself able to order direct individual measures, such as the release of detained applicants, to order the restoration of the professional activities of human rights lawyers, activists like Intigam Aliyev. And they've also ordered wider general measures. So, for example, in the Navalny case, to require the Russian authorities to amend the legislation on right to demonstrate. That didn't end up so well, of course, given the developments in Russia, but it's an important precedent nevertheless. And those cases have also led to, in some cases, to convictions being overturned, partly through the process, the pressure of the Committee of Ministers process. Just to finish, other procedural innovations in Europe, we now have the infringement proceedings process, which has only ever been used twice, in which the Committee of Ministers can decide to refer a state back to the court where it fails to comply. And it's been used in authoritarian context in Azerbaijan, and more recently in Turkey in the Osman Kavala case. And we have another procedure that as yet not been used, the complementary joint procedure, in which the Committee of Ministers, the Parliamentary Assembly, and the Secretary General of the Council of Europe could come together. We have this process that was set up or established 5 years ago now. It's never been used, and that's something that we could come back to. Başak, I'm going to leave it there, and looking forward to the discussion. Thanks very much.
Thank you, Phil, for introducing a range of, I suppose, tools and procedures that both the European Court of Human Rights and the Committee of Ministers have used, and look forward to coming back to some of these and their effectiveness also in the discussion. Over to you, Adam.
Thank you very much, also from me, for the invitation, and hello to everyone joining us. I'm supposed to speak quite quickly, briefly about how particularly the African Court has provided platforms for challenging authoritarian measures. But before I start, I think it's good to note that, in Africa in particular, and I imagine in Latin America, we're kind of used to the kind of authoritarian tactics, deploying the law to undermine freedom of speech, essentially civic space and political pluralism, but also some of the measures that violate the law to undermine democracy. And so the experiences, insights, and ingenuity of civil society and other actors in our sphere of the world perhaps provides a lot of lessons for those who are now trying to fight the sort of resurgence of authoritarianism in some of the more established democracies. Having said that, if you look at the African human rights system, particularly the litigation, the protection element of it, it kind of had to confront the challenge of authoritarianism. In fact, the first case that the African Commission on Human and People's Rights had to grapple with was a coup d'etat in the Gambia, which is host to the Commission itself. And that case in the early 90s involved a democratically elected government removed by the military regime. And the removed government approached the African Commission, and the Commission said that all of what happened violated the right to self-determination, the right to political participation of the people. Now, fast forward to the establishment of the African Court in 2006, and again, the court has grappled with one of those fundamental issues. Sorry, just a second. Sorry, was somebody ringing a neighbor was ringing the bell. And so the African courts similarly had to grapple with the challenge, but it faces more dangerous patterns in the sense that the protocol establishing the African court does not create automatic rights to approach the court for individuals and non-state actors. And in that regard, most recently, in March 2025, Tunisia withdrew a declaration allowing individuals and non-state actors to submit cases against the country. And now you'll understand, I'll quickly come back to it, you'll understand how this withdrawal poses a significant challenge to the entire idea of a supranational tribunal trying to protect fundamental rights against authoritarian limitations. I'm going to give two quick examples, and I've chosen the two examples carefully to show how two countries that were quite hopeful in terms of their democratic trajectory are kind of, one has essentially completely become an authoritarian system, Tunisia. Another one is still on the margin. We hope it won't completely collapse, which is Benin. And in Benin, one of the cases, there was a case in 2020 which was submitted to the African court, and that involved a new law. Part of it was adopted through a constitutional amendment requiring political parties and political candidates to have what are called sponsors. And so if you want to run for a political office, you need sponsors from across the country. And now, at the face of it, this was intended to encourage parties and individuals to have a national character. But in reality, particularly the requirement that you need support from elected local governments meant that the ruling party essentially can prevent a lot of other candidates from challenging it. And the African court said you cannot do that. So even if the law was changed, even if the constitutional amendment was adopted through a regular process, it said it did not involve broad consensus. And the constitutional amendment, because it did not involve broad consensus, was incompatible with the ideas of democracy at the African level. And in Tunisia, again, as you know, the new president, Said, came to power. And one of the first things he did was ban the National Assembly and essentially conduct an auto-gallop, a self-coup. And following that, there was a challenge again in the African court saying, this violates the right to self-determination, the right to political participation, and the court agreed with that. Now, the challenge is that, as I said, Tunisia withdrew recently the permission, the declaration allowing individuals and NGOs to submit cases, and Benin also did it a few years ago, withdrawing from the African court. And perhaps more concerningly, despite the decisions of the court, the African Union actually sent electoral observers subsequent to the illegal and unconstitutional measures that these governments took. So in a way, it was legitimizing the refusal of these countries to comply with the decision of the government. And in a way, this kind of leads me to the challenge. One is the fact that countries can actually deprive individuals and NGOs access to the court. So without leaving the court, they can limit access to the court. And so they can claim the benefits of membership without the consequence of it, which is a big challenge. The second one is the African Union, which is supposed to be the institution that is supposed to pursue the enforcement of these decisions, is not doing enough, which speaks to the difficulties of a large organization that does not have the leverage of, for instance, the European Union to force countries to be members, particularly important countries. And in general, I think today there's a sense of, for me, a challenge to the whole idea of multilateralism, and perhaps this will come during the discussions. It is affecting the rest of the world as a whole, but also Africa, in the sense that the importance and viability and influence of supranational organizations like the African Union is under question. And in that context, if you see the sub-elements of these entities, such as courts, they are going to continuously face challenge to confront governments that are authoritarian and also sit in these institutions. But overall, I would just say that the African court, credit to it, has been very prominent in terms of pointing out violations, some of them quite key. And these have had, I think, an important message in the sense of sending a sense of solidarity with the people that are suffering under authoritarian regimes. But in terms of actually making an impact, perhaps I think, unless we look at it through a longer term perspective, it's very tricky to imagine a situation where these authoritarian regimes sitting in the African Union will actually hold themselves accountable to the decisions that the court takes. I'll stop there, and I can take questions later. Thank you.
Thank you. Thank you so much. I mean, this kind of almost took us to a different level of discussion, in the sense of, from the question of how regional courts could respond through judicial decision-making to what happens when institutions that set up these courts are co-opted by authoritarian states. So I'm sure we will come back to the second level of complexity in our discussions as well. And with that, Viviana, looking forward to your intervention.
Well, good day, everyone, and thank you very much for this timely conversation. I think that we're living through testing times, and it is a perfect moment to reflect about how international human rights litigation can help us with the well-known tools and with new tools in sustaining democratic gains and rights around the world. International human rights litigation has been critical in confronting democratic backsliding, resisting authoritarianism, and responding to coup d'etat in the Americas. As Adam was saying, for the African system, I think that the Inter-American system of human rights protection grew out of their response to coup d'etats and authoritarian practices and governments. And it has kept on trying to tackle those entrenched and new authoritarian trends and expand democratic gains throughout its history. In our context, I would also say that international human rights litigation has been actually critical in responding to some of those trends, and in some cases it has created historic tipping points and has helped truly resist and resist authoritarian practices and gain rights. However, we have significant challenges in litigation and the tools of international law. And I would try to do my presentation focusing on two aspects. One is the well-established uses of international human rights law for resisting authoritarian practices in our region, and also put some of the new frontiers to confront authoritarian regimes and highlight some of the challenges that we have today, with the caveat that international litigation is not the same, or doesn't have the same outcomes or serves the same function in different regions, even in different countries and topics, and that creates severe limitations as well to how you can use that tool in different countries and situations around the globe, and specifically in the Americas. But also, I think that in thinking about the challenges and the new frontiers, we have to see how international litigation, the legal standards and the tools have also adapted to meet the times, and how international litigation can also serve as a path for making the law evolve, as Professor Leach was saying, and also as helping develop new tools. For example, expand the scope of interim measures. In our context, develop a whole very complex system of supervision of the execution of judgments or special rapporteurships. So on the well-established uses of international litigation to confront authoritarian regimes in our region, I would say that they have served primarily three functions. One is expose the truth. Second is protect key individuals and the civic space. And third, advancing democratic norms and rights. On exposing the truth, and I think that some of the litigation has served as an early warning mechanism in our context. It has also helped create a public debate about trends or practices sometimes new trends or practices domestically and internationally. We have seen that, for example, in Ecuador, in Peru, in Mexico. It has also, in some contexts, contributed to create an official record that has been very important for truth telling processes and transitional justice efforts, for example, in Argentina. On the protection of individuals at risk, organizations and civil society groups and the civic space, there's also a long development of tools and measures that have benefited from an expansive use of collective measures of the Inter-American system, of interim measures that have a collective impact, as well as litigation that has protected organizations and have also led to reparations that are very expansive in nature, such as changes in the laws and policies to protect human rights defenders under threat in Colombia. And there's as well a very interesting case in Brazil dealing with those issues. Those are the cases of Cajar in Colombia, Ginette Bedoya in Colombia, and Sales Pimenta in Brazil. And then on advancing democratic norms, I think we've seen it, the Inter-American Commission and the Inter-American Court challenging the erosion of institutional checks and balances. For example, the dismantling of the rule of law in Peru, in Venezuela, in Guatemala. We have seen it as well limiting impunity for gross violations, which is also a key tool for expanding authoritarian rule in countries such as Guatemala, El Salvador, and Peru. We have seen it expanding and protecting political rights, which is also a critical part of responding to authoritarian rules, and reimagining justice at critical junctures, such as expanding the understanding of women's rights and the need to confront violence against women or crimes against humanity. Now, on the new frontiers, I think that there are some of the issues that we have to think about when looking at the state of the law and the institutions and rethinking what is needed to respond to the big challenges of today that need that really confront the architecture and the practices of international human rights litigation. One, and I highlight four areas. One is structural challenges in international human rights litigation to meet the current moment, thematic ones, a funding crisis, and challenges to international protection. I will only talk about the first two. On structural challenges, I think that the whole process of thinking and developing the law is obviously very state-centric, and it focuses on accountability. But some of the authoritarian practices and trends include other processes where the law has not necessarily met the challenges that we have to deal with corporate actors, with criminal networks, with climate-related harms, for example. There are also delays in how international litigation responds, how fast it can respond to the trends, and how effectively can execute them and help implement the decisions of international courts. So those are two aspects that are very interesting. And in the execution of judgments, I think it's very interesting to think about what Professor Leach talked about on the different procedures, as well as rethinking some of the political and economic conditionalities that could happen through other actors that could help in the implementation of judgments. Then on the substantive and thematic challenges, I think that some of the emerging topics that are having an important impact on states and regions, they really require a rethinking of the law, but also of issues of attribution, evidence, standing, reparations. And I think that the climate justice discussion is a very important one. And there in the Inter-American system, we've tried to accelerate the response to that through prodding a couple of governments, Colombia and Chile, to present a request for an advisory opinion on the topic to the Inter-American Court on Human Rights. But there's a lot that still needs to happen in order to adequately respond to the harms and the needs of protecting rights and using rights to accelerate their responses to the climate emergency. Similarly, issues of disinformation and limitations on erosions of civil society participation, not only thinking about censorship, but also about how to secure environments that structurally can create a space for an open public debate is a critical area, as well as the weaponization of legal frameworks, which is something that I think we've seen in Africa and in the Americas. But international human rights law, and maybe this goes back to Article 18, has more difficulties to deal with this type of democratic processes that implode democracies from within, or that operationalize the legal process in order to persecute groups or people. So I will leave it there, and I hope that we can also talk about issues of how the current funding crisis of international human rights law, or the chilling environment for the multilateral solutions, can also have a very critical impact on our possibilities of using international human rights litigation for sustaining democracies.
Thank you. Thank you very much. So we are looking forward to your questions, which you can pose by using the chat function. We have about just under half an hour for discussion. As people are maybe thinking of putting down their questions, perhaps I could start with one of the questions that was a theme that was also raised in all of the three interventions. And this has to do with the law. So not about the institutions, but just about the law. And I think all of you have touched on this. A lot of research that has been done, perhaps not by lawyers, by political scientists, by sociologists, they do talk about an authoritarian playbook, and there are lists of things that are included in a playbook. There are sometimes 10 steps, sometimes 15, sometimes 20. So there's quite a lot of insight. But this knowledge is not created necessarily by judges or by courts, but by people who are deeply embedded and who are actually following these processes. So we, on the one hand, we seem to have a lot of knowledge about these practices and how they work. And of course, all of these authoritarian playbooks say that sort of a legal pretext or ulterior kind of purposes or hidden purposes are really part of the unfolding of it. And Viviana, you've also mentioned it. So using law to undermine democracy is a key issue. So given that, if you agree that this is a core problem of today, so we're not talking about coup d'etats, but coup by law or by constitutional amendments. Do you think that these regional systems have the adequate doctrines or the speediness of the doctrines or the depth of the doctrines to respond to these types of problems? Let's start with that, and I hope we can continue to talk about other institutional constraints as well.
Shall I go ahead?
Please do. Yes.
Yeah. Okay. No, so I think, you know, I happen to work with an organization that is currently working around those issues and how, in particular, law is used to narrow civic space, to narrow political pluralism, and essentially to undermine the fundamental premises of democracy. And we actually have a recent, quite a recent report written by my colleague Samit Bisaria and a PhD candidate at the University of Oxford, Madeline Rogers, entitled "Resisting Backsliding," and it kind of tries to capture the different tactics authoritarian regimes in different places deploy, and the kind of tools to resist those deployments, those measures that actors like civil society and, you know, committed political actors committed to democracy can use. And coming back to the question in terms of how supranational human rights bodies can have a role in taming that, I think when there is a sort of a full-blown authoritarian shift, I think it's very difficult. Just like institutions at the domestic level struggle, the supranational level similarly struggles. And as you know, because of the principle of exhaustion of local remedies and all, before cases actually stream in, before they make it to the international level and debates occur and a decision comes out, it takes quite a lot of a long time. But when there is a sort of a broader agreement on the fundamentals of democracy, I think they can play a role. And a good example is a case before the African courts. It was against Burkina Faso before a military coup occurred. And there was a law that provided criminal punishment for defamation. And the African court said, you know, you can prohibit defamation, but you cannot criminalize it, right? And the African court in particular, I think perhaps even more than the European court and the Inter-American court, kind of considers itself as the constitutional court of sorts. It reviews laws, the compatibility of laws, even constitutional amendments, with standards at the African level. And so that claim to the authority to review the validity of laws and not just implementation of laws and all, I think kind of gives it a robust authority to play a role. Now, if you look at the modern authoritarians, and unfortunately, you know, I think in the old days, even actors that are not very democratic tend to claim they were democratic, right? And they were sort of afraid, so to say, of being named and shamed. But today's autocrats actually like the limelight. You know, they don't really worry about being named and shamed. And so, in terms of, I think, how they can be relevant for me is the sort of camaraderie, the sort of visibility that they provide. And so, you know, if you are somebody in Tunisia fighting a battle that you think you cannot win, but you find an African court sitting somewhere agreeing with your cause, you know, supporting the arguments that you're making, or if you are in Benin trying to challenge a president that for all reasons is trying to shift the democratic pattern that the country has gone through, I think that camaraderie, that cross-border support that comes with the decision is important, even when the decisions are ultimately not implemented, and even when institutions like the African Union essentially don't do their job and follow up on those cases. And so I think there is value in these institutions, and I think if you look at litigation as part of a broader strategy, and this was perhaps the point that I tried to make at the beginning, litigation is a part of a broader strategy of mobilization to challenge authoritarian regimes. And in that sense, winning or losing is not necessarily the purpose of the case. It's to add to your cause, to add visibility to the broader social, political mobilization that's out there. So to that extent, I think they remain very, very relevant aspects of the entire spectrum of strategies that we can deploy.
Thank you. Viviana?
Yeah,
Yeah,
no, I can say that as I was noting at the beginning, I believe that each regional system has its own history and tools that can be deployed differently to handle this democratic backsliding or even full-blown coup d'etats. And in different countries, the experience over time, the experience has rendered different results. So we have seen situations where international litigation has actually been very important in limiting the trends domestically. I can say, for example, that in the case of Peru in the 90s and the beginning of the 2000s, that was absolutely the case. Currently, there are, and it took different tools of the Inter-American system. It took precautionary measures, reports by the Inter-American Commission, judgments from the court, then the use of political tools that existed at the moment for the political guarantee of democracy at the international level. It even led to the adoption of the Inter-American Democratic Charter. So, and in that process, like the different actions of local actors, journalists, politicians, human rights organizations, victims, judges, it really worked in order to overturn a very authoritarian government and create processes of change. Currently, we're seeing a backsliding in Peru, and there are more difficulties to deal in the current context, even with the same tools, but less appetite from political actors to respond to that. But we're seeing in Guatemala that there is more appetite and more tools being deployed by the political actors at the OAS and the Inter-American Commission and the Inter-American Court in order to respond to ensuring a democratic transition and the rule of law and some elements of human rights. And so that is to say that I think we have tools, but they work unevenly, and they can work to different purposes. In the case of Nicaragua, it is working more as, which is a country that has gone through a full implosion of any democratic check and balance, and it has worked, as Adam was saying, just to, tell the story, bring it outside, and keep some level of solidarity and maybe improve a little bit the prison conditions of people, but it hasn't really overturned the process, because as you were saying, Başak, and I think historians and political scientists know it better than we do as lawyers. Those social and political processes need not only the law, but they need other actors. But I think the tools that the Inter-American system has developed, the political tools and the legal tools have been critical, and because of the experience that it had to face early on, it started talking about the illegal use of legitimate legal tools. It developed some of the language and the doctrines that were very useful since the 90s to deal with some of these processes. Now, what I think is that we're in a different moment, because I think that some of the authoritarian playbook is not only having deep consequences domestically, but is creating waves of authoritarian practices that seem legitimate in many societies, and that, I think, stresses the tools that we have.
Thank you. Well, in the meantime, I have had quite a few questions in the chat. So before I come back to you, Phil, maybe I'll join a few of the questions and let's see which ones we will be able to address. So this is kind of a follow-up on the question that I was asking about law and institutions. But Phil, perhaps you can respond to this one I'm going to post to you, and maybe another one. And this is from Alice Donald, who highlights the Judge Darian Pavli's separate opinion in the latest Novaya Gazeta judgment about the need for the European Court to develop new tools, as we were talking, as well as use existing ones, and to allow to address authoritarian practices cloaked in law. This is what we've been talking. And the Judge Pavli's suggestion was that dealing with successive individual cases should not blind the court to the wider pattern, which he likened to seeing individual trees and not realizing that the democratic forest is on fire. So she's asking any thoughts on what these new tools might be. And in the Strasbourg context, for the Strasbourg experts, this will be easier perhaps to understand. Alice is asking, are there any tools other than the pilot judgments or Article 46 judgments? So Phil, maybe you could briefly talk to that. And perhaps you can also very briefly respond to a question by Jeffrey Kahn. And Jeffrey Kahn is asking, was Russia's participation at the European Court worth it? In very short, but you can read the longer version in the chat.
Thank you. Great questions. I'll try and answer them in a couple of minutes, although we need a couple of days, couple of weeks. Alice is right to draw our attention to the Pavli individual opinion in the Novaya Gazeta case against Russia just earlier this year. It's really worth a look. Have a look at that. It's a case about a load of applicants and media organizations protesting about war in Russia and all the measures that have been taken against them. So it's a remarkable decision. But Darian Pavli adds a remarkable separate opinion, which essentially calls on the court to do more. And I think he's absolutely right. We have seen, again, in the last 20 years or so, the European Court using pilot judgments, using Article 46 indications to broaden out its perspective. This is a court that, of course, has always been based on individual rights, individual applicants, looking at individual cases. That's been changing, but I think it could go further, and that's what Darian Pavli is saying. So, he's saying even in Article 18 cases are about seeing the systemic practices, but he says the court could go even further and by going into even more detail, even more depth to try and work out what the problems are. I think he's absolutely right about that. He talks about new stock-taking tools for the court. I think that is right. We need to be more aware and more decisive in countering these systemic problems. But there are things, I think there are things that still can be with the tools we have. And of course, I would say it's always much more difficult to establish new tools than use the ones we got. So, for example, Adam and Viviane have talked about the problems of delay. Just to give one example for the European Court, the case about foreign agents law in Russia, Echo Defense, it took 9 years for the court to decide that case. There was no need for it to take 9 years. In that time, a number of the NGOs and the leaders of NGOs who were applicants were effectively abolished or abolished themselves or were prosecuted and jailed. I would say these systems have got to reasonably use meaningful reprioritization processes, and I think that would be significant. And then there's so much to talk about, but let me come back to Jeffrey's question about Russia, and he asks, was Russia's membership at the Council of Europe worth it? And of course, as you all know, Russia was expelled 3 years ago as a consequence of its brutal invasion and occupation of Ukraine. So we've had 25 years of Russia in the Council of Europe. And on a personal note, I've been involved at the European Human Rights Advocacy Centre with litigation against Russia for most of that period. And it's been extraordinary in many ways. And Russia has engaged with the processes, even in the gross violation cases from Chechnya, the extrajudicial executions, torture cases, enforced disappearances, and so on. Russia engaged in those processes. It even paid the damages awarded by the court, and some people are surprised to hear that. What is true, of course, is that they didn't do anything beyond that. They resisted carrying out effective investigations. So it's a very mixed picture. But what I've always said about the Russian cases is that it's provided important, a very important measure of justice in providing some measure of truth and some measure of redress. And I think Vivi was talking about the right to truth. Well, we don't know, in the future of Russia, how the hundreds of judgments against Russia will be used, and they need to be used. They are a remarkable sort of document of what's happened there. So I think, Jeffrey, try to answer your question. I think the decision to expel Russia, was right. On the other hand, it's a punishment also for the people of Russia who can't now use the courts, and they're deprived of that possibility of getting partial justice and partial redress. And the great challenge for the court, to come back to Darren Pavlou, is if you look at countries like Turkey now, what's going on in Turkey, is the court able to do enough? Is it, as Darren Pavlou asked, is it raising the red flag? Is it raising the alarm signal loudly enough and early enough? And I think there's more it could do. There's much more I could say, but Başak, I'm going to stop there for the moment.
Thank you. I mean, we have quite a few interesting questions, but let's see. I think we might be able to get to 2 more questions. One of the questions, which was also flagged in both Adam and Viviana's presentation, was the collapse of the multilateral institutions that actually sustain regional human rights systems and courts. And one of our participants is wanting to hear more about the chilling environment for multilateral solutions and what this means for thinking about using international human rights mechanisms and litigation for authoritarian practices. Perhaps, Adam, if you could reflect on this a little bit more, that would be fantastic. And then finally, I'd like to perhaps ask Viviana to respond to another very important question. And of course, others may want to chip in as well. And this is the final question we could probably take. And this is about whether international human rights litigation is capable of addressing financing of authoritarian practices, i.e. corporate complicity in human rights violations in non-democratic states or the corporations supporting authoritarian actors and leaders. So, Adam, over to you.
Thank you very much. I think it's a big dilemma. Obviously, these institutions were established at a time where the idea of democracy was in the ascendance, right? So the hope at the moment these institutions were established was that, for some people, as you might remember, history kind of had ended, right? So there was one way of going, and that was upwards for democracy, and that has completely changed now. And not just that the idea of democracy, But the belief in multilateralism, in a rules-based, international law-based order, is suffering. Of course, there's still a lot of, there's a large aspect of international relations that's regulated by law, but on the things that matter, on human rights, on conflict, on attacks by one country against other countries, there is a very, very difficult situation. And what I find interesting is that the big countries may have an interest in trying to bypass international law and international systems. But smaller countries like European countries or African countries and Latin American countries cannot afford to live in a wilderness. And so I think particularly Europe, until the European Union kind of becomes one big animal, one state, if all that happens, I think there is a significant interest in each country maintaining the international system, because that's how they regulate their relationships, and they regulate the relationships they have with other parts of the world. And so it is suffering, and what that means is that human rights systems also suffer. There's no question about that. But I still hope that there will be significant interest in it, because for some big animals, the wilderness may be a nice place. But for the majority of the mid-sized animals, rules are critical. That's what can keep us from Thomas Hobbes' state of nature, literally, between states. So I hope that it will recover, and that recovery then will hopefully also bring back the importance of human rights as fundamental to the interactions across borders. Thank you.
Thank you. Viviana?
There are many challenges in dealing with corporations participating in authoritarian trends and the financing of authoritarian practices. But I think we have different tools that we've used in the past and that we can think to deploy now to deal with the authoritarian playbook, because we also have a democratic playbook that needs to evolve, but we can also learn from what we've done in the past. And I think in terms of the practices, there are some strategies that were head-on developments, legal developments, that have been useful for highlighting some of that support and financing with some of the cases, and they look at the roles of paramilitaries and non-state actors in the complicity with and in committing gross violations of human rights and crimes against humanity. And there are several cases of the Inter-American Court that deal with that, including a long thread of cases in Colombia, for example. There is doctrine and jurisprudence on corruption and on state capture as well that could also be useful to deal with these types of actors. And then there are, I think, indirect tools that we can use in order to deal with these types of actors, that maybe is not a head-on analysis of what's happening, but it can also have an important impact on dealing with this, which is strengthening the jurisprudence on transparency and proactive access to information, which is critical. Develop the law and jurisprudence on consultation, prior consultation and participation, all the standards on human rights defenders and civil society, as well as different theories of reparations that could push the boundaries of the types of responses that we could get. I think that to deal with these types of actors in the Inter-American system, we started with the theories of reparations that the European Court had, and we evolved that over time. And we evolved in parallel processes, institutional and legal processes with the European and the African system as well. But maybe there are things to rethink at the European level, looking as well as at the evolution of other systems, because there might be solutions within the existing law if the jurisprudence could change slightly, as it has changed in the past. For example, for dealing with the need to investigate those that participated in crimes against humanity or human rights violations. Could the European system also evolve, or has it evolved to deal with more structural legal challenges to democracy, such as restrictive laws as the foreign agent laws?
Thank you. Thank you very much to all our participants and to all my wonderful panelists. We have quite a few other questions that we weren't able to get to, but I think the discussion so far does show that this has to be a very ongoing conversation, and it's not a conversation that can be just had in just in a one-off sense. But I hope that all our participants will also appreciate that when we think about authoritarian practices and countering and resisting the authoritarian practices, one of the things we also need is to think collectively and collaboratively about these practices. These are not isolated incidents happening in one part of the world, in one corner of the universe, but they're actually, as we said, quite widespread, and we have to really learn from one another in thinking through as our practices and our resistance evolve. So I think huge lessons to be learned from the inter-American system and the African system and practices, as well as from Europe. So let's not mention that part of the world as well. So thank you very much. Our third webinar is going to be happening in about 3-4 weeks. You would be able to find the information on the websites of the Bonavero Institute of Human Rights, as well as the Matrix chambers. And we're going to be discussing frontiers and challenges in litigating, equality, and non-discrimination in the next webinar. Thank you very much.
Thank you very much again, Başak, and everybody.
Thanks a lot for this opportunity. I learned a lot.
Thank you.